Hello, everybody. Here we are on my live show. I want to welcome everybody, whatever time of the day or night it is. I hope you're going to enjoy today's topic. We're talking, you know how I do it all month. I do my little videos to kind of lead up to this great and wonderful live. So I kind of give you little spigots throughout the month to get you interested. So you can say, hey, wait a minute, this is pertaining to me, or maybe this is pertaining to a friend or family member of mine that I can help them out, or even show them, hey, here's this video by this attorney. Why don't you watch it? And it could help your situation. We all know that, today's topic obviously is a family law topic. And, families can be very, how do I say this? A very sensitive subject and a very emotional subject because we're dealing with our children and with our families and stuff. So that's why this month I thought, well, it's heading into summer and the kids are out of school. And if you're not together with the father or with the mother or the other parent, that this is kind of a good time to talk about family law issues. But a couple of things I wanted to kind of go over before we start. Obviously, I like to give people a little time here to get all settled in and to get logged in. If you're like me, sometimes you have some technical issues that you got to take care of. So that seems to happen. So I give people time to do that. But some technical issues, I do want to tell you in June, I'm traveling. So I'm not going to be doing an actual live show. What my staff is going to do is they're going to kind of cut and paste and give you little spigots of important issues that I've talked about over the last couple of years. I was thinking before we started today, I wanted to say, welcome to my 150th live, but I don't know. I'm going to have to get with my staff so we can count and see how many of these I've done so I can say that the next time. I would like to know just for my own well being and to know, hey, how many of these have I done? How many are out there in the world? But anyway, so what we're going to do is we're just going to do little spigots and then have a rerun of a bunch of my lives kind of put together. I'm going to be traveling out of the country. I'm actually going to Zambia. Yes, I know people are, anytime I tell them where I'm going, they're like, Zambia? They have no idea. Believe me, I had no idea. I had to look it up. It's in Africa. So I'm pretty excited. I've never been to Africa. We're going to be going on lots of safaris and giraffes and elephants and who knows what I'm going to see. So I'm very excited about it. So unfortunately, I won't be able to do an actual live, but don't worry. We'll be taken care of. We'll be taking care of you, making sure that you still get the information that you need. And then in July, we'll start right back up again. And we've already discussed it and settled on a topic. We're going to talk about criminal proceedings, when you get stopped and what they look for and all those kind of stuff and how best to protect yourself. So that was one of the little housekeeping things I wanted to talk about. Also, what I wanted to talk about, as you know, I did a podcast. So my very first, I do know that's my first one, my very first podcast, Law Time with Lauren. It's on Spotify. And this month, because it's still May, May's topic was the death penalty in the United States and in Florida. And so I felt it, I enjoyed researching it and I enjoyed doing it. So next month, June, I'm going to release, it's going to be on the abortion law. As we know, here in the United States, Roe v. Wade was overturned. Oh, does that make abortion illegal, legal, whatever? We'll talk more about it during my podcast. So I just wanted to get over some of those housekeeping things while people get settled in and kind of get maneuvered in before we get started. So anyway, again, I want to welcome you to my live. Today's topic, as I said, a petition to relocate. So get settled in. Have your water like I do, your water, your tea, your coffee, your soda, whatever you may be using right now to hydrate, your Gatorade, whatever it may be. Make sure you have that. Make sure you have your little snack if you want to snack while you're watching me, your popcorn, your pretzels. What do I like to snack on? Grapes. I love my grapes. Have those handy and you can just sit back. If you have a question, remember, type it in and I'll be sure to answer it because that's what I'm here for. I'm here to answer any questions that you may have. Think of me like a free attorney right now. You can ask me whatever you want in regards to the topic we're talking about, and I'll be more than happy to answer you if I can. Understanding I'm only licensed in Florida, so I can't answer a question out of Arkansas or a question out of Minnesota or a question out of California. I can only answer specific questions. If you give me a question and it's maybe specific to a state, I'll tell you to, contact an attorney in your area. So anyway, let's get started. So as I talked about, topic today, petitions to relocate. What does that mean? What do you mean a petition to relocate? Can't I just move? Isn't it in the United States Constitution that we all have a right to travel and live where we want, correct? We can travel. I can travel to Minnesota, I can travel to New York, I can travel to Texas, I can travel wherever I want. It doesn't matter. I can live wherever I want. That's what we're allowed here in the United States. The only drawback with the petition to relocate is if you have minor children and you and the other parent have separated, either through divorce or through what we call here in Florida a paternity case, meaning the two of you had a child together, you weren't married, and now you separated. And now you have a court order that says this is when one parent can see the child and this is when the other parent can see the child. And remember what we said that was. That's a parenting plan. A parenting plan is a roadmap of when each of you get to see the children or the child. So once that's set in place, it puts your current address, where you're living. Hey, I live in Orlando. The father lives 10 miles from me at such and such an address, and we're exchanging our children, having a great time. We're co parenting great. All of a sudden, I want to move. I want to move to Miami, which Miami is like 4 hours south of Orlando, in case you didn't know. Can I just take the children and say, bye, Dad, and take off to Miami? No. I have to either get written consent from the other parent, meaning I agree, here's our alternative parenting plan. Everybody signs it, we file it, we get an order approving it by the court and showing that it's in the best interest of the child, that child or children, that they move to Miami with me, but that there's still this time sharing plan where they can see the other parent. If I don't get written consent by the other parent, I got to file this petition to relocate. And the petition to relocate is referenced under Florida Statute 61.13001. In the event you're wanting to look it up and maybe it's pertinent to you and you can look it up and read it and be familiar with it. Even though sometimes you read it and you're like, I still don't get it, right? I still don't get it. Or it sends you to another statute and you're going off and you're going down a rabbit hole pretty soon. So petition to relocate is 61.13001. And what it spells out is if you don't agree. It talks about when you do agree and what's required, but when you don't agree, you have to file the petition to relocate. And so the petition to relocate says that I want to move more than 50 miles from my current residence, the last residence that was used for the last final judgment, either providing for time sharing or modifying the time sharing. Now, I had a judge in the past tell me, oh, counselor, I just take it from the courthouse and I do a circle around it. And whatever more than 50 miles, that's what I look at. And I was like, no, it doesn't say in the statute, the courthouse doesn't say that. It says my place of residence, my last place of residence. So I've had people move actually 47 miles. And how do we measure that? Do we go into MapQuest and put the addresses and, oh, look, no, we don't, because MapQuest can kind of send you around and around. And if there's construction, we do it as a crow flies. So I actually will Google, as a crow flies, what is the distance between such and such and such and such? If it's under that 50 miles, I'm good to go. If it's more than the 50 miles, then you have to file the petition to relocate. Now, let's talk about the petition to relocate. Once it's drafted, and we'll go over what are the elements that need to be required to be put into petition to relocate. But once you draft it, you file it with the court as you do with anything else. You file it in your open case, and then the other party has to be served. So served, as a process server, knock, 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 here you're being served. That person then has 20 days to respond. Now, if they don't respond, they say, well, I don't care. This isn't really going to happen, and they throw it away. Guess what? You don't respond, the court will default you, saying, well, I guess you agree with it, and you're saying that it's in the best interest of the child, so we're going to grant it. So you always need to make sure that you answer any legal pleadings that come across your desk or come across your threshold. Make sure that you respond, whatever it may be. If you object, you need to put why you object. What's the reason? What's your relationship? All of that. Why are you objecting? You file that objection, you provide it to the other person within that 20 days. Now you've got an objection. Now the court has to move forward and what we call a hearing, more or less a trial going forward. So on whether or not it's in the best interest of the child. Now, to draft that petition to relocate, in that petition to relocate, for it to be legally sufficient, you need to talk about a job offer. If you're moving because of a job offer, let's say I want to move to Miami because I've been hired by the Miami Heat. I know some of you are kind of sensitive about that right now, but it's okay. It's okay. But I want to work for the Miami Heat. The Miami Heat have given me a job offer. They want me to be a dancer, which would be kind of funny. But anyway, they want me to be a dancer and they've given me a job offer and they've given me terms and dates of starting and how much I'm going to be paid and all of that. I need to attach that to the petition because I need to show the court why I'm moving. So that job offer has to be attached. If I just reference, oh hey, I got a job offer from the Miami Heat here and I file it, that's not legally sufficient because we need to know what kind of job is it? What are you going to be doing? How much are you going to be paid? Because those are the arguments that potentially the other side is going to go against, saying, hey, she's going to make less money down in Miami as a Miami dancer than she is going to be here in Orlando as an attorney. That doesn't make sense. That's not in the best interest of the child. And we want to make sure that everything is in the best interest of the child. So that has to be attached to the petition. So, and it needs to be detailed. I've had cases where they've sent me job offers, and the job offers were they were interesting. But hey, I attached them. I don't know where they came from, or I've never heard of the company before. But that's not for me to question. I attach them, and then the court has everything that they need. So if it's because of a job offer, you cannot be general. You need to attach, and you need to have details. And a lot of times our clients say, "Well, I didn't get a letter. They just gave it over the phone." No, then have them give you a letter. Have them send you an email, whatever it may be. Make sure that you have proof of that job offer. So that's one thing. If you have a job offer, you need to have it based, you need to attach. Now, the other thing that needs to be in there is an alternative long distance parenting plan, because that's going to be different than your local parenting plan, right? Local parenting plan, you're doing maybe 50-50. Maybe one parent has a Monday to Monday and the other parent has a Monday to Monday. That's not going to work if I move to Miami. That can't work if one parent is living in Orlando and one parent's living in Miami. 50-50 is not going to work. That's not in the best interest of the child. To ship them back and forth, what are they going to do? Attend two different schools? That doesn't make sense. So you need to attach an alternative long distance parenting plan saying exactly what's going to happen with the time sharing. When is the other parent going to be able to see this child? Now, Miami, it may be a little easier to see, maybe every other weekend. You drive up and meet the person halfway. I don't even know what halfway is. What, Indian River? I think that's a little too south. But anyway, where they meet halfway, take the child then comes back Sunday. Whether or not that's in the best interest of the child, that seems a lot of driving. But either way, it could be in every other weekend. Now, imagine if you moved out of state. Every other weekend's not going to fly because you can't. It's not feasible. So maybe you're saying, okay, they get a majority of the summer, they get a majority of the holidays, spring break, those kind of things. So you put that in there. So you put exactly what's going to happen, what do you want done, and how is the transportation going to go? So is it is it going to be by plane, train, automobile? What's it going to be like? And how is that going to be divided financially? So, who is going to pay for this plane ticket? And does somebody have to travel with the children? If you've got young kids, you can't just put them on a plane and say, see ya. Some parents don't feel comfortable with that. If they're teenagers, okay, they have, what do they still? I don't know if they still do that, but I have the flight attendants kind of be in charge of them. Is that what you're going to do? Or is each parent going to go back and forth with these children? If they do, okay, are the parents paying for their own plane tickets? Who's paying for the children's plane tickets? Are they going to split? One parent pays one way, one parent pays the other way. That could be very pricey, especially if you're doing summers and holidays. That's when the prices go up, right, to travel. So you need to have some kind of financial situation in there and how you're going to provide that. If you don't have that alternative time-sharing plan, your petition can be thrown out specifically just on that. You need to have that in there, and you need to be specific as possible. I've had clients put, well, he can see the children, whenever he wants. No, that's not going to work. the court can't enforce something that says dad or mom can see the children whenever they want, because there's no way to enforce it. So you have to be specific, just like you're doing a brand new parenting plan. That's what I do for my clients. I just give them a blank parenting plan, say, okay, put all the guidelines and everything you want and the parameters in it, send it back to me, and we'll attach it to the petition to relocate. That's the easiest thing to do. So, anyway, the next thing we do is obviously the best interest of the child. That is what the court always looks at. They look at the best interest of the child. Is it in the best interest of the child to leave and go to a whole new environment, a whole new school district, a whole new area where they may know nobody, they've lived in, let's say in my case, okay, let's say Orlando. They've lived in Orlando all their life. They have friends, they have activities, they have the rest of their family here. And I say, okay, I'm going to take them to Miami. They've never lived in Miami. They have a whole new school district. They have no friends down there. Is that in the best interest of the child? It may be in the best interest of me because, hey, I got this great job with Miami Heat, but it may not be in the best interest of the child. That's it. The court will always look at that. The court will never take your interest over the child. It's always going to be about the child. So, which is a good thing because it always should be. Because why? Because the child can't verbalize what they want or what they need. And so that's what the court's role is to do, is to kind of be an advocate for that child. So anyway, what the court looks at, they take into factors when they're looking at whether or not it's in the best interest of the child. Kind of like this, it's the same kind of factors the court uses when they're looking at a parenting plan or a time sharing plan. They take those same factors in account. They take into account the quality and the extent of involvement that the parent that's relocating and the parent who is non-relocating. What kind of relationship does this child have with both parents? Is this child really involved with both parents, and both parents are very involved in the upbringing and very close, and maybe there's stepchildren or half siblings or something that they're involved with? What is the extent of the involvement? Or is the one parent that's non-relocating, are they absent? Are they really don't exercise their time sharing, and they're not involved? The court's going to take that into consideration because they don't want to, if the other parent's involved, they don't want to take that child and now that other parent is left. Gosh, I was seeing that child every other week, and now I can't see the child until every other weekend, or not until summer, or not until the holidays. That's a lot on that child not being able to see that parent. I got to give you an example. It doesn't have to do with a petition to relocate, but it has to do with a parenting plan. This couple was divorcing. I was watching it, but they weren't clients of mine. I was watching it in court. And it was an 8-year-old child, I think. And the parents did a parenting plan where the child would be with one parent for 30 days, and then the other 30 days would be with the other parent. So it'd switch off month to month. And the court would not approve it. The court said, no, this is not in the best interest of the child. Now, it may be easy for the two of you, but it's not in the child's best interest because an 8-year-old child can't go 30 days without seeing the other parent, where that child was every day of their life until you separated, seeing both of you, and now going 30 days without the other parent. That just wasn't in the best interest of the child. So the judge, she was really nice. She goes, why don't you go in the back and why don't you discuss it a little more and see if you can come to a better agreement? But I'm not approving this because it's not in the best interest, because it's not allowing that time sharing, that appropriate time sharing. The court is also going to look at the age and the development of the child, meaning, is the child special needs? Is there anything specific? How young is a child? Is a child, a child always needs both parents if both parents are involved and willing to be involved. So they're going to look at that. Are there special needs? How long has a child been in the community? If they're older and they've been in the community all this time, will that have an effect? If they're younger and pulling them away will have them not be very familiar with the other parent. The court will look at that. And then the court also wants to look at how can they preserve that relationship with the non-relocating parent. If that non-relocating parent is involved and wants to maintain that relationship, how can the court do that? Well, the court ordering this relocation shatter or divide that relationship. So they want to make sure, because I used to teach these parenting classes in the state of Florida. When you divorce or you separate from a relationship and there's children, you're required to take a 4-hour parenting course. Now, this was back in the day when we didn't really have internet too much, so we didn't do it online, it was in person. And I remember I had a video that I would always show them. And in that video, it would say, your children, you chose your partner to have a child. This child did not choose his parents. So no matter what your relationship is between the two of you, that child still looks at you as both mom and dad, as long as mom and dad are both involved. So, hey, Agus, how are you? Good afternoon. How does the court determine the child's best interest? Well, that's what we're going through. We're going through the elements now. Great question. Like I said, the nature and extent of the relationship between the two with the children and the parties, the age and developmental stage, uh, having preserving that relationship with both parents and the non-relocating one specifically. The next one is the child's preference. Now, the courts don't usually put a child on the stand and ask them questions, because that really can be harmful to the child. If you put a child on the stand and say, okay, which parent do you want to live with? I mean, think of that. Well, if I say mom, dad will be sad. If I say dad, mom will be mad, or mom, or whatever. That's a lot to put on a child. That's a lot to put on somebody who's at a young age and the maturity level. So the court, I've never seen that. They maybe take into account, maybe if there's a guardian ad litem, the guardian ad litem is speaking on behalf of the child, but they kind of look at the maturity and so forth of the child. And then they look at and these are the factors that I'm going through. So, and like I said, you can also look 61.13001. They specifically spell them out in a little more detail than I'm telling you now. Now, they also look at a great question, whether the relocation will enhance the general quality of life for the relocating parent and for the child. Meaning, if I lived in Orlando and I couldn't find a job, I can't find a job. I can't find a job. I can't find a place to live that I can afford. I'm having difficulties here. If I move to Miami, although Miami is probably a bad example because it's more expensive in Miami, but let's just say if I go to Miami, I'm going to be making more money. I have a place to stay. My family lives down there. I can stay with them until I get enough money to get a place. And it's just a great opportunity for me. It's going to enhance my life, therefore enhancing the life of my child. They'll also take that factor into consideration. So that's why when I said you have to have that job offer attached, you can't just say, well, I'm going down to Miami to look for a job, so I want to move down there. No, because then you're taking this child, and who knows, if it takes you 6 months to find a job, where are you going to live? What are you going to do? How are you going to support yourself? So you need to have that job offer attached to show that, hey, it's going to enhance my life. So then the court also looks at the reason for the relocation. Obviously, you need to have a reason, not just, well, I want to change the scenery because I want to be closer to the beach, because I want to be able to go and to the beach anytime I want. Well, that's not really a basis to move. If it's going to better your life, it's going to enhance the life of you and the child. That's what they'll look at. But being closer to the beach, like I said, here in Orlando, what? Think an hour at the most I'm away from the beach. I don't know. I don't go to the beach much, unfortunately. I should go more, but you're not that far. So the court would be like, well, you can always drive to the beach. You don't have to move down there to be closer to a beach. So then the court looks at the current employment and economic circumstances of each party. And so if both parties are gainfully employed and they're making money and all of that, okay, why the move? What's going on? What's happening? Why are you wanting to do this? Now, I have had cases where one parent is not working, or maybe they're working from home. Maybe they're working from home or they're not working. And the other parent who has a job, they want to move because they got a promotion or they want to make more money and they're moving. And the person who doesn't have a job or working from home objects. The court's going to be like, well, parent that's working from home or doesn't have a job, you could move, or if you're not working and you're working from home, you could work anywhere. You could work in Miami. You could work what's close to Miami, Fort Lauderdale. You could move and work there. So holding back somebody from making themselves better and trying to enhance the life of the child, you really you're not making a good argument because you're working from home and you can continue to work from home. Or if that parent has been ordered to pay child support for the child and that parent has not been paying child support, do you think they have a leg to stand on to object to the relocation if the relocation is to better the life of the child and the parent, for them to get a better paying job to help support themselves? You're going to have a very, very, very tough road to go down if you're not supporting that child, because then it's like, well, you really don't have a say in where she lives. She's got to support this child because you're not paying any child support, and he or she has the sole responsibility of paying for this child. So you got to, and I've had those cases before where you've been ordered to pay child support, they're not paying child support, but they're still objecting. And yeah, I just look at the judge and go, they haven't paid child support in 2 years maybe, and now they're objecting to moving so that this person can better themselves. So the court will take that into consideration. Um, and then if there's any history of substance abuse or drug abuse or anything like that that maybe hindered that individual's parenting ability, the non-relocating parent maybe hindered their relationship. I did have a case like that where mom had, a history of drug abuse and all that, and abuse. DCF had been called on her several times for abuse, and she was objecting, and the court took that. Now, everything that I'm going through is not the sole reason. Okay, she had drug abuse, so no, I'm denying your objection and I'm granting the petition to relocate. No, the court looks at all these factors, and it's kind of a, what do I want to say? One big pot where they kind of look at it, they stir it around and go, okay, based on all these factors, is it in the best interest of the child? So they don't just take one. And some of them may not even apply. Like maybe there was no drug abuse or domestic violence or anything. So the court would just say, okay, NA, not applicable. It's not applicable in this case. Now, the last factor they take into consideration, of course, is the catch all and any other factor that may show the best interest of the child. And they refer to 61.13. Now, 61.13 Florida statutes refers to the creation of a parenting plan or a time sharing schedule. And they go into a whole list of factors, which are pretty similar to these, but don't discuss the relocation. They just talk about the involvement of both parents and how it'll affect all of that. I think it goes like A through J or something. It's a very lengthy elements. So anytime I go to court and I'm wanting a petition to relocate, I filed a petition to relocate on behalf of my client. I will go through all the factors in this petition to relocate, 61.13001. Then I got to go over to 61.13 and catch any of them that maybe weren't in 61.13001. So it can be very tedious going through the elements and trying to prove those elements, putting my client on the stand, maybe family member, whatever it may be. But anytime the court, it's so funny because all the laws generally say, and any other, they always like to catch that. And any other could be anything, right? Anytime we're talking to somebody, we're trying to make our point, we're like, and you know what I mean when we run out of argument. But anyway, I think I saw a question pop up. I'm not quite sure. It could have been my eyesight. There we go. Oh, I hope I'm saying this correctly. Now, I hope. Hello, Attorney Sterling. Hello. My question is, what information do I need to include in a petition to relocate? Well, that's what I'm going over. I'm going over if there's a job offer, you need to attach the job offer. You need to put in an alternative time sharing plan for the long distance. And then also you need to point out how it's in the best interest of the child, how it's in the best interest of that child to move with you, and if will they have a better life. Also, very good question too, Noel, because I think it's Noel. That's how I want to say it. I could be wrong. I'm one of those that pronounce things how I see them. It's probably wrong. So I hope if I'm pronouncing your name incorrectly, I apologize. But good question though, because I'm going to transition now into the kind of the miscellaneous requirements for the petition for it to be legally sufficient. And what I mean by legally sufficient is we call it in law, to survive a motion to dismiss. A motion to dismiss, which I've had many and I've filed many, goes off the petition. If I do a motion to dismiss the other side's petition to relocate, I'm looking at the four corners of the pleading. That's what the court looks at. They strictly look at the four corners. They don't look, well, I meant this. No, no, no. You meant what's in the petition. So they look specifically at the petition. And if I say it's legally insufficient, and why is it legally insufficient? Go over this again. It it mentions a job offer, but there's no job offer attached to the petition. Number two, there's no alternative long distance parenting plan. They need to have a long distance parenting plan. Otherwise, it's legally insufficient. Number three, it doesn't show that it's in the best interest of the child. It doesn't say why it's in the best interest of the child. And finally, it's missing things. First of all, it's got to be signed under oath and affirmed under penalty of perjury, meaning under penalty of perjury, this is true and correct what I'm signing. So I'm signing it under penalty of perjury. So if I lie about something, I'm looking at a penalty being charged with perjury, meaning lying in the petition. So it's got to be signed with that little oath there. I usually have the oath, I have them sign, and then I have a notary. I like to just make sure it's all taken care of. Then it needs to have a description of the location of the relocating parent's new residence, the whole address. It should not just say, I'm moving to Miami. No, 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 no. It has to say, I am moving. I only know Biscayne Boulevard. I know that in Miami. I am moving to 655 Biscayne Boulevard, Miami, Florida, the zip code, whatever that may be. And if you happen to have a home phone number. I don't know who has a home phone number anymore. I know my parents have a home phone number. I don't. I just have my cell phone. But if you have a home phone number or your cell phone's going to change, you need to put that in there as well. Otherwise, it can be dismissed because you're not completing, you're not giving the court or the other party all the information. Also, the mailing address. If the mailing address is different than the physical address, some people use P.O. boxes and stuff as their mailing address. So if you have that there. Also, the date of the intended move or proposed relocation. Now, I've had people that have already moved and then they want to file a petition to relocate. So I have to backdate and say they moved, January 1st and now it's February 1st and I'm filing this. So you have to put the date of the intended move. If it's now, May 30th. If I intend to move July 1st, I need to put that in the petition. July 1st and the year, some people forget the year and they're like, July 1st, what? That actually would make it legally insufficient if you didn't have the year because July 1st, what, 2026? We don't know. So that would not survive a motion to dismiss. So also in the petition needs to be in big, bold, capital letters. And I'm going to read it out of the statute. A response to the petition objecting to relocation must be made in writing, comma, filed with the court, comma, and served on the parent or other person seeking to relocate within 20 days after service of the petition to relocate, period. If you fail to timely object to the relocation will be allowed, unless it is not in the best interest of the child, without further notice and without a hearing. That verbiage has to be in the petition, and it has to be capitalized and bold because it's kind of, what do I want to say? It's kind of a flashing light telling you, hey, this is what you got to do. I guess because people in the past have said, well, I didn't know I had 20 days. Yeah, you did. It was in capitals and bolded on the petition. So that language, exactly like that, is written in the statute and it needs to be in the petition. If it's not legally insufficient, will not survive a motion to dismiss. So as I stated, you file the petition, you have them personally served by a process server. No, you can. I have so many parties go, well, I can bring it to them. I can bring. No, you cannot. I have to have a process server. And let me tell you why. A process server, first of all, because when do the 20 days start? The 20 days start the day they're served. So day one would be the very next day. If they're served on a Monday, day one starts Tuesday. In the state of Florida, process servers cannot serve on a Sunday. Sunday's out. If you're served on a Sunday, it's improper service. You need to have it squashed. So let's say you're served on a Monday. It would start, day one would start Tuesday. And the only way I have proof that you were served is the little affidavit from the process server saying that they served you and what address and a description of you and what exactly was given. And they're doing it under penalty of perjury and they have it notarized and everything. And I can file it with the court. And then the 20 days start. What I do in my office is we mark it on the calendar. When is that 21st day? On that 21st day, I'll file a motion, or yeah, a motion, I guess we call it, to the clerk requesting a default. And so the clerk can default if they have not responded. Now, if they respond, but it's a legally insufficient response, then I got to go in front of the judge and ask for a default because their response is legally insufficient. And what always happens is the judge gives them another chance to amend and whatever. So they get a chance to amend their answer. Potentially, that's if they know to ask for it. Generally, the judges are, they're wanting things to progress on their merits. So they may give them a little opportunity. So it always frustrates me. Although I've asked for an opportunity to amend and I've been given it. So I guess I shouldn't complain. Anyway, so that's kind of what the court does. Now, if, oh, Gracia. Oh, what a beautiful name. Gracia. Gracia? Garcia. What a beautiful name. Good afternoon, Attorney Sterling. Can the other parent object to the petition to relocate? Yes. Just like I said, the verbiage in there talks about the 20 days. They have 20 days to object. And they have to make sure that they get that answer in within the 20 days. And I'll have clients call me on the 18th day. Hey, I got this thing and I got an answer. I go, okay, why don't you send me a copy? And I see when you're served with something, with legal documents, there's a summons on the front and the process server will stamp it with the day and the time that you were served. So it'll say there, May 15th. 2023, 8:05 a.m. Now the time's not really that important. It's the day. And so that way it says right there how much time you have left. And so they'll send it to me and I'm like, oh my gosh, you have 2 more days. What the heck? Why'd you wait so long? Well, I forgot about it and I put it over there. No, please, as an attorney, I'm begging you. If something comes across you and you've been served with it, please get with an attorney immediately, because otherwise it really puts us up against an 8 ball as far as being able to answer in an appropriate way. So, but yes, good question. Yes, they can object if they don't want them to move. If they don't feel it's in the child's best interest, they have the 20 days. Make sure they keep track of those 20 days so that you can get your objection in. So, anyway, let me take a little drink here so I can take a little breather. Now, like I said, sometimes parents will take the child and just move. I had one that took the child to Wisconsin. She didn't tell my client from Florida. Remember, I'm in Florida. She took the child to Wisconsin. She didn't tell my client. The only reason my client found out was because she was posting on Facebook. I tell you, Facebook gets you every time. This social media, it'll get you every time. She was posting on Facebook her travels because she was driving in a little moving U-Haul. Oh, here I am. Yeah, I don't know. Here I am in Tennessee. Oh, here I am in Georgia. Here I am in Illinois. And she was posting it all along. So that's the only reason that he knew that she moved. And so he quickly went in because there was a court order that set up time sharing, but she felt she could just move and not have to worry about it. But that's not how it works. So he went in and filed. This is what the non-relocating parent can file if there is a time sharing or a parenting plan in place. There's already been a final judgment. They have time sharing. They've been sharing this child, and the other parent just gets up and moves. We file what's called an emergency motion for a child pickup order. And so what that's saying is, hey, court, we had this final judgment. I was to get the child 50% of the time, and mom took off to Wisconsin. Here's my proof. Here's pictures on Facebook. Here's this and that. I want the child returned to this jurisdiction. Because if the final judgment was entered here in the state of Florida, Florida maintains that jurisdiction unless it's moved. So if it's still here, the non-relocating parent can say to the court, hey, I want you to claw back. I want you to claw out and order that child back here to Florida. Now, the case where the mother took the child up to Wisconsin, yep, we got a court order here that directing the sheriff up in Wisconsin to take that child into custody and hand the child to my client. However, you go to Wisconsin. Wisconsin's like, yeah, well, we don't know. Okay, maybe we'll get around to it. My client actually had to go to court in Wisconsin, get that order solidified, get that order from a court in Wisconsin, serve it on the sheriff in Wisconsin, and then the sheriff took him to the mother's new home and was able to take the child. I want to say take the child, but mom, when she saw the order, she kind of willfully gave the child because he really, you want to avoid that. You want to avoid this strange sheriff coming to the house and taking this child. And so luckily he was there and mom said, here, she handed the child over to dad and then he was able to bring the child back to Florida. And then they were able to, then she had to file a petition to relocate and request to take that child to Wisconsin because she couldn't just take that child just on her own whim. There was a court order. It was identifying him as dad, identifying her as mom. There was a time sharing in place. You can't just move on a whim. Now, could the court use that against her that she just kind of took off and went to Wisconsin without permission of the court? Yeah, they can take that into consideration. They're not going to take that 100% into consideration, but they can say, well, ma'am, you're not one to follow court orders. So if I order it's okay for you to take the child to Wisconsin, how, are you going to follow the long distance parenting plan? You didn't follow the first parenting plan we had in which you were to share this child. So they can take that into consideration. So it's best always to do things how you're supposed to do them is to get to know the law. Okay, I want to move to Wisconsin. Let me see what the law is. Let me see what I need to do to make sure this is legal. Let me make sure I need to do what is right so that the sheriff doesn't show up at my door in Wisconsin asking me for the child, because that can be very, what do I want to say, traumatic for the child. So we want to make sure that everything is in place and that you get permission. I had a case where the mother took the child, I don't remember, let's say to Tennessee. I can't remember what state. Took the child from Florida to Tennessee. We had, I think, yes, we had a final judgment for a time sharing plan, and she took the child. And we did a petition. We asked the court to return the child. I had to go back and forth with the court a little bit. They didn't want to do it. They didn't want to do it. And I understand why. That can be very traumatic. They were two boys, and I can understand that's very dramatic. But I was like, listen, Florida has jurisdiction over these children. You need to bring these children back, and then she can proceed with what she wants to do if the court's going to grant that petition to relocate. So the court did order those children back. My client got the children because he was living in Florida and she was still bent on living in Tennessee. So that was her choice. We went through the whole process. And unfortunately, in the end, the court granted the petition to relocate. So sometimes they can use it against you, but it's not 100%. They're not going to say, no, you did this, you can't have it. They could still grant it, saying it's in the best interest of the children. Of course, there were certain issues with my client that he traveled a lot and all that kind of stuff. So that's potentially why the court did it. But, they look at all the factors. Again, the ones that I listed, they don't just look at one and say, okay, well, you did wrong, so bad news, so you don't get the kids. No, they'll take that into effect, but it's not 100%. So now, Christopher. All right, that's one I can pronounce very well, I hope. Christopher, I've sole custody of my 4-year-old child. Oh, God bless you. The mom's parents have visitation Sundays. Oh, wow, and grandma made comments about her not letting my child be alone with her husband and told me not to dress her in a dress unless she wears tights. Is this grounds for restricting the visitation order? Well, I guess I would need more information on that. What's going on, what's happening. You're saying that, I don't know what state you're from either. I don't know if you're from Florida or not. In Florida, grandparents aren't really considered in the whole time sharing thing. So, commend you for letting grandma and grandpa still see the child, because here in Florida, you could just say, okay, grandma and grandpa, I'm not going to let you see the child. But it just would need more information about, okay, what's going on. If you have sole parental responsibility, you make all the decisions. If there's a court order that says sole parental responsibility and you have that, if you're here in Florida, then you make all the decisions. So you decide. Now, if there's a parenting plan that still says that the other parent gets time sharing, you still need to abide by that. But if you feel like there's something going on, I would recommend you talk to an attorney in your area, whether it be in Florida. Hey, be happy to help you. Give us a call. Or if you're in a different state, contact an attorney in your area that specializes in family law. So if you have, like I said, if you have sole parental responsibility, in the state you're in, you may want to look that up and see what you can do. Here in Florida, you would make all decisions. But again, then you got to look to see if there's a parenting plan in place that says what the other parent gets. And you can always, at least here in Florida, if you feel that something is going on, ask for a supplemental petition to modify to say, hey, this parenting plan's not working and this is why. And then the courts need to decide on that. But very good question, Christopher. And sorry you're having a hard time. A 4-year-old is so, so little and so vulnerable. So hopefully you're doing your best, and whatever you may need, if you're here in Florida, we're here for you. Otherwise, like I said, talk to an attorney in your state. Thank you so much, though, for that question. Okay, so sometimes the court could grant a temporary order to allow you to move with the child while you're proceeding down the avenue of the petition to relocate. That doesn't necessarily mean if that court grants a temporary order that that's going to turn into permanent. So, but they can allow it for whatever reason they may want to allow it. They can grant a temporary order for relocation. Now, people always come to me, and even in criminal cases, in every case, they always say, oh, I need to prove this and I need to prove that. If I have a criminal client, they always need to say, I need to prove my innocence. And I always tell my criminal clients, no, 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 no. The state has a burden of proving your guilt. You don't have the burden of proving your innocence. So, in a petition to relocate, the burden of proof is on the relocating parent. They need to go through all those factors that I spelled out for you to show the court that it's in the best interest of the child. That's their burden. The non relocating parent just sits back and lets them, present their case. Now, if the court says, okay, they turn to the other side. So now it's the other side's job. If I'm objecting to the petition to relocate, now it's my job to show it's not in the best interest. And so I take those factors and I put them towards my case. Hey, it's not in the best interest because I have this long-standing loving relationship with my 4-year-old, right, Christopher? I have this long-standing loving relationship with my 4-year-old, and I love her and I want to take care of her and I pay child support and I see her every week and da 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 da, showing that, hey, I'm involved and I want to continue to be involved. And if she moves to, or he or she moves with the child to Wisconsin, I'll only be able to see him during the summer, Christmas holiday, maybe spring break, and that's it. And my child depends on me. This is what I do with my child. That's when you present your case. And then that's when the court decides. But the initial burden is, we call him the petitioner, the person petitioning for the petition to relocate. So it's their burden first. So we don't go first in objecting, saying why we object. They have to show that it's in the best interest of the child or the children. So that's kind of in a nutshell what a petition to relocate is. Generally, in every state in the United States, they have some form of petition to relocate. So your best bet is, if you're wanting to relocate, is to check with an attorney in your area. You can always look up and Google petition to relocate to kind of get an idea, but it's always best to talk to an attorney, because when you do things on your own, sometimes is when you kind of pay that price of doing it, because it's not the right way and it gets thrown out and you're frustrated and you're delaying the process, and maybe it's a job offer and it's only good for 30 days or whatever it may be, and you're on a time crunch and you're doing it on your own and it's not progressing like it should. As an attorney, we can kind of push it along and push it along to get it taken care of. So if you're thinking about relocating, now here in the state of Florida, again, it's more than 50 miles. I don't know what it is in other states. Again, talking to an attorney and getting to know that information. So I hope that I provided you with the information that'll help you, and that taught you about the petition to relocate. Please know, again, feel free to give our office a call if you're here in Florida. I'd be more than happy to discuss with you about the petitions to relocate. I've done so many petitions to relocate, whether it's I'm petitioning for my client to relocate or I'm objecting to the other side relocating. I've done a lot of them, so I have a lot of experience with these petition to relocates. But please feel free to call our office and make an appointment, and I'd love to talk to you. And also remember that I have my lives each month. I have my little videos each week that you can watch. And then also I have my new podcast. Yay! So remember to watch it on Spotify. We just released it May 15th on the death penalty. And next month we'll be talking about abortion issues here in the state, or here in the United States and in Florida. So you all have a great, fabulous, beautiful day. And I hope to see you next time.